Hey everybody, thank you very, very much for joining us again and watching our videos. We are here to help sellers around the world, and what I want to do right now is introduce David Miller. He's one of our lawyers here. He's an associate lawyer here at the firm, and we're going to be talking about brand protection, and we're going to talk about the top 5 issues for brand protection from David's perspective, who is helping private label sellers all over the United States. He's also helping private label sellers from abroad. So, David, on your list of the top five factors for private label selling, what is the number one thing you want to talk about?
Well, first I want to talk about how long it takes to register. Some people always have questions about, what can we protect? How long does it take? What do we do? So, start with trademarks. Essentially, for trademark law, you do not have to register your rights to be protected. Now, I'll touch on how Amazon compares with that, but in general, for trademark rights, you do not have to register. Once the products are in use, once you're selling it in commerce, you have trademark protection.
Now, this is one of the big differences between U.S. law and Chinese law. U.S. law is first to use.
Correct, and Chinese law is first to register.
100%. So, but we believe you should file for your mark. So while you do have some protection, you should absolutely file for your mark. And the amount of time it takes from doing the application with the United States Patent and Trademark Office, how much time are sellers looking at between applying for their mark and getting the government's approval?
It's usually between 6 months to a year. We generally say 8 months, but we've seen it stretch out to a year. So it could take a while, actually.
Now, the forms are also very, very easy. We are big at paying it forward. So if you're a seller, you develop a mark, go to USPTO.org, USPTO.org.
.gov.
I'm sorry, .gov, USPTO.gov, and you can fill the application out yourself and give it a shot. If it gets rejected, you'll receive what's called an office action. And then if you need us to address it, we can do it for you. It's one of the services.
Correct.
So the number one issue is the timeliness, how long things take.
Correct.
All right, what's number 2 on your top list, your top 5 list of issues for brand protection for private label sellers?
So one thing people, I think, ask about is if you don't have to register, let's say for trademarks, why register at all? Like, you have trademark protection, why do you have to register? There's a few reasons. One, especially particularly with Amazon, they don't really love complaints that do not have registered trademark rights. Now, again, legally, you still have trademark rights, but it's a lot harder to file complaints on Amazon without trademark rights. You're dealing with, they're not usually lawyers who are reading your complaints. They'll get confused, and a lot of times it's a lot harder to protect, essentially.
So one of the things that I've learned from doing these arbitrations against Amazon is who is reviewing the IP complaints. And listen, most complaints are successful, but then if the seller stands up for him or herself, they hire a firm like us to stand up for them, and you don't actually have a registered mark, it's difficult to defend.
Correct.
So also, you're talking about other platforms. eBay wants to see a registration, and AliExpress requires a registration.
Correct.
They follow more the Chinese model. So I believe you should file. It's easy to do yourself. It's inexpensive to do yourself. And the things you gain are just easier enforceability and a more persuasive complaint if someone is hijacking your listing.
Correct, and I will say this: it's easier if you do a test buy and you can show that the product is counterfeit. It's a lot easier to get a complaint through to Amazon. But if you haven't done a test buy and you don't have any registered trademark rights, it's way more difficult.
All right, what's number 3 on your top 5 list?
Number 3, I want to talk a little bit about cease and desist letters. Essentially, what this is we reach out to all hijackers, we call them, on Amazon, and we give them a chance to amicably, resolve the situation before we file complaints. We're not in the business of cutting sellers' legs off. We want to reach out and let them know. A lot of sellers don't even know that they're violating trademark law or copyright law or patent law, whatever the case may be. So we want to give them a chance to remove it on their own. A lot of times they'll say, "I'm so sorry," and they'll remove it on their own.
It's also, we do that because not only is it who we are in terms of the moral way that we practice, but I think it's good business for sellers. It is so easy for a competitor to either leave you a negative review or have their friends, family, spouses, neighbors buy your products, return them, leave you bad reviews. And if it's a seller that has a significant staff, like in China with labor costs being so low, they can easily just trash your listing if you needlessly harm them. So we think it's not only the right thing to do morally, but it's good business not to needlessly create animosity with people who can just totally trash your listing. So the reasons why we always give sellers, we always give hijackers the opportunity to come off your listing amicably is one, we think it's the right thing to do. Also, number two, you don't need to create animosity, and it's also very efficient.
Correct.
I mean, we run like 60-70% of hijackers will remove themselves as soon as they get our C&D letter.
Exactly, and it's also way cheaper. We don't have to go through the process of filing a report, which brings me to my next topic, which is reports of infringement. So basically,
this is number 4.
This is number 4. Sorry. After a cease and desist letter, like CJ said, a lot of times they'll get a response and they'll remove the listings on their own. But if they don't answer, or if they, whatever the case may be, they decide they don't want to remove their listing, they don't think they're infringing, then we'll take it with that, we'll take it up with Amazon and we'll file a report of infringement. Now, what goes in the report of infringement?
Well, let me interrupt a second.
Yeah.
So we follow a two-step process. Okay. First, once you've identified the hijackers, once we've identified the hijackers, we'll send a C&D and try and get those sellers to come off amicably. The ones that refuse, either they don't contact us, they simply say no, or we can't amicably work something out. Like, I'll give you an example. If there's a hijacker who contacts us and says, hey, listen, I've got 30 units left. I just started selling. Can we sell out our inventory and then we'll stop? We'll often work out agreements with the hijackers so that they amicably come off the listing.
Correct.
Now, if those efforts fail, then we go to the complaint system and all bets are off. Okay, and so the complaint system, if you can, describe how the complaints are lodged within Amazon's website to remove hijackers because they're selling counterfeit, they're not coming with the warranty, the significant differences. We don't make bullshit complaints. We only use the complaint system when it's absolutely valid to protect your brand and also to protect the consumer.
Right. So there's a few different ways of filing complaints with Amazon. One is the report infringement page. We don't use that as much. The main reason is because you can't attach documents. I think there's a few hundred word count. It's just not enough for us. Usually we have a lot more to explain, a lot we want to say. But essentially that is pretty simple. Pretty much you send them a list of ASINs. It could be the entire listing, a seller name that you want to remove, and pretty much they'll ask for your registered rights. So what's your registered trademark number? That's really it. And then a paragraph or so about what, any details you want to explain.
Now, if you're not going to hire us to protect your private label brand and you want to give it a shot yourself, I want to give you a couple of tips. Amazon does not enforce distribution agreements, and distribution agreements are not intellectual property rights.
It's actually number 5 on my list.
Oh, I'm stealing number 5.
Still number 5.
What you need to do if you're going to file your own complaints is stay away from the word distribution or authorization or anything in that regard, because Amazon will sometimes see that word or see those words and then throw out the significant complaints. And it doesn't make any sense. But we've learned a tremendous amount by doing arbitrations against Amazon, and it seems almost like a knee-jerk reaction. You can claim counterfeit, trademark, copyright, and distribution, and they see the word distribution and ignore the rest of the complaint. So you want to avoid those type of complaints.
Right.
So now I just took David's 5 out, so right here on the spot, he's going to come up with a 5th point when it comes to brand protection.
I guess just in general, that's exclusive distribution. That's one of the baseless complaints. I've seen other baseless complaints like MAP, so minimum advertised pricing. Certain individuals want to file complaints like, oh, you're selling below MAP. Basically, all that means is there are certain sellers out there that want to keep the minimum price at a certain range, I guess, to create more competition. So if someone's selling way below that, they're going to destroy their competitors.
So the 5th tip, okay, is to not assert baseless complaints. Don't assert authorization. It's not a valid IP complaint. Don't assert distribution. It's not a valid IP complaint. MAP pricing was basically gutted by the United States Supreme Court back in 2007, so don't claim MAP pricing. I would also add to what David said is that you also don't want to claim that the customers are yours or that the listing is yours. I mean, you don't own the listing. This is a creation on Amazon software.
Correct.
You don't own it, and that sort of runs afoul of the way Amazon reads these things. So that's the top 5 of David's ideas on brand protection, on dealing with hijackers. And if you have any specific questions or concerns, unlike Amazon, you can actually call and speak with us. If you want to speak with David, you can call us. If you want to speak with me or any other member of our team, you can call us. You can also email me directly. The email address is cj@amazonsellerslawyer.com, and the phone number is 877-9sellers. We are also now available from practically 8 a.m. Eastern Time every morning, all the way around the clock to 4 a.m. Eastern Time. Now, how are we doing that? We took one of our long-term paralegals, one of our managing paralegals, Vincent Famularo, and we shipped him off to Melbourne. So he's now living and working in Australia with all the training that we have here in New York, and he's available to you. So we're practically around the clock with the time zone. It works out to be about 5.5 to 6 days a week. And if you're a private label seller and you have questions, concerns, please feel free to give us a call. David, thank you for coming on the video with me.
Thank you.
I drag my team out here because not only do we get to give you information, I get to introduce our team members to you. And please, if you've learned anything from this video, please like it and please share it. Thanks again.
Thanks, guys.